Thank you for joining us this afternoon. For those of you who I do not know, I'm Timothy Heinley with the UNC School of Government, where I have the privilege of working with all sorts of kinds of civil defense attorneys in different proceedings, especially those involving indigent respondents. I'm going to be joined today by Anique Lenore-Peak, the parent defender with Indigent Defense Services for North Carolina. I will introduce her in a little bit, but I appreciate you all being here. It's so nice to see so many familiar names, even though I can't see your lovely faces. Do know that this presentation is being put on in what's called webinar mode, which means your cameras are not on, we can't see you, you cannot unmute yourself, but you can ask questions in the chat. Please feel free to do that. It can be a little bit difficult for us to see those questions in real time. If we're able to answer them, we will. But the good news is Anique and I will get a transcript of the chat after this, and so we can follow up with you individually, or maybe you'll ask a question that makes for a good blog post, and we will follow up one way or the other with you then. But thanks for being here, and with that, I'm going to jump in. So Anique and I wanted to spend some time this afternoon talking to you about social services records. These cases have everything to do with kids, but a whole lot to do with records. Records that are maintained by DSS, created by DSS, sought by DSS. They can have a big impact in these cases in a number of ways. And so part of what we want to cover is going to be what's in these records, how are they maintained, what are the rules around confidentiality, and how can you access these records? And does it make a difference if you're a party in an abuse, neglect, dependency case or a termination of parental rights proceeding? Or if you were in some other kind of civil proceeding, how could you go about accessing these records? And I am going to spend some time with you all on admissibility of DSS records and the contents contained therein. And also I'm probably going to point out 7 or 8 really common pitfalls or traps for you all to be thinking about when you think about what records you want to offer, and when you are thinking about trying to keep records out that maybe social services or the guardian ad litem attorney are trying to offer into evidence. And then Anique is going to take over, and she is going to cover with you various tips and tricks from the DHHS manual. How can you use the guidance, the rules, the policies that social workers are supposed to be following to help your client and maybe to weaken your opponent's case. So with that, let's jump in. First and foremost, when we talk about DSS records, what do we mean? What's in the box? At first, I wondered whether this reference was a little too unpleasant for this webinar. And I thought, well, DSS records are pretty unpleasant in a number of ways. But what do we mean by DSS records? It's important to be clear because that term gets thrown around to mean a number of things. It can mean records that were created by a social worker. It might be an investigative social worker. It may be in-home services workers or foster care workers or some other kind of DSS employee. The term DSS records also is used to mean records created by third parties, right? We see this all the time. When DSS walks their records into a courtroom, they are rarely carrying just a small manila folder. They are often dragging some sort of wagon with banker's boxes in it, because their records are not just the records created by social services, but their files house documents that were created by third parties, doctors' offices, law enforcement, other groups. And so the term DSS records sometimes gets applied to those sorts of documents as well. And you want to be clear, as we'll discuss over the next hour and a half, when you're making a motion or a request or an objection, you want to be clear about what records you're referring to try to get the best outcome you can on an issue. And lastly, sometimes DSS records, that term is used to mean court records, the juvenile abuse, neglect, dependency, or TPR files that are maintained by the clerk. And there's a treasure trove of information in these records. And some of you will no doubt hear me and think, of course, I look at these records all the time. You don't have to tell me to do that. But I think it's pretty common practice, too, for parent attorneys to not consistently get access to these records, which is, I would suggest to you, limiting your arguments limiting your evidence in juvenile A&D and TPR cases. The files that DSS houses, the records that those files contain, can tell you an awful lot about the people in these proceedings, including your clients, their history, the interactions that they have had. There might be photographs that tell a different story than the petition tells. There's information about emergency room visits, psychiatric history, pharmaceutical history, mental health. There can be police records and evidence of domestic violence history, housing issues, leases, treatment options, reports about what others in the community have called and told social services. The list goes on and on. There can be good things for you to know to promote about your client. Sometimes I think defenders, understandably, because of the posture of these proceedings, end up just playing defense. They're just the goalie. DSS is slapping pucks at the goal, and the parent defender is trying to knock them down. But there can be things for you to promote about your client. You've probably, if you've ever attended one of our joint SOG and IDS programs before for parent defenders, you've probably heard us talk about the compelling reasons for you as a defense attorney on behalf of your client to have a theory of defense, to have a story, a narrative to tell the court. Social services gets to file the petition. They get to cherry pick what the court hears first. They get to frame the case using that petition. When they file court reports, they are framing the discussion through those court reports. That is the window into which the court is first viewing your client and their family and their history. Part of your job, I believe, is to find what you can. What is beyond that petition? What does that petition not say about your client? What does that petition not say about the relationship between parent and child? What is the petition or the social worker in their court report or on the stand not telling the court about your client's history, your client's needs, what services your client would benefit from, what efforts social services needs to make to help your family? The department is charged with trying to help keep your family together, put your client's family back together until reunification efforts are ceased. You can find information in these files, in these DSS records, to help support that. There's this notion at disposition of tailored dispositions. And what I mean by that is, rather than in every case, DSS submitting a court report that says the department recommends the following, and it's the same seven or eight boilerplate terms, things for your client to do. You've probably seen this, right? You've probably had a case where there's no allegations about drug abuse, for example. There's no allegation or reason to think that your client has abused substances. And yet, in the disposition report, the department or the GAL may ask that your client be ordered to submit to drug screens. That is because some departments, some GAL offices are used to taking boilerplate language, boilerplate recommendations, and trying to apply them to every client, to every parent, because their thought is, and maybe innocently enough, it would be good for us to know whether this person is using illicit substances. But your job as the defense counsel in these cases, in part, is to redirect the court's attention to what matters, to what is relevant, and to what will help your client get their child back if they have lost custody. You also want to look in these records for the bad stuff, though. There are things in there that could hurt your client in every case, and it's better for you to learn about them so that you can prepare for how you're going to address them if they come out in court. When you reach out to social services, and we'll talk about the different ways that you can seek access to these records, but when you're in the process of asking for records or making a motion for an order that would require the department to disclose records, make sure you ask for what you need. I will tell you, I spent several years as a parent attorney at the trial and appellate level, and I also spent several years as a social services attorney at the trial and appellate level. And I will tell you, having sat in both seats, but especially my former role as a DSS attorney, you will get requests sometimes for records, whether it's information sharing or a motion, and you will know that the party has not asked for everything that there is. But if your opposing party only asks to see 10% of what's out there, or if a court only orders that you turn over 10% of what's out there, what DSS has in its files, that is what DSS is probably going to turn over. Narrow requests allow for narrow disclosures. So I would encourage you to think about when you make a motion, when you make a request for access to information, make sure that you're being clear about what you need, what you are looking for. Do you want child protective services records? Do you want adult protective services records? Do you want both of those things? And about who? Are there certain incidents that you're only looking for information on, or do you want certain reports, certain years? Maybe you're only interested in everything from 2023, when a baby was born, forward. Or maybe you want something going back to when siblings were born. Don't limit your request in a way that allows your opponent to not turn over information that you might have otherwise been given access to. Do you want information and records about just the investigative phase, or also the in-home phase, also the foster care phase? Your client, your client's immediate family, or are we talking about somebody else's family, somebody else's kids that might be relevant in one of your proceedings? So cast a wide net. It's beneficial. It's going to sound a little bit counterintuitive, but you can be both broad and specific at the same time. So you can say any and all child protective services and adult protective services related to the following individuals, and then name them, for example. And that might help you gather information to use in court, or just in preparing for court, preparing a theory of a defense, preparing your client to testify. That information can be really useful. It helps too, by the way, I don't want to malign social services here. They may not be maliciously failing to turn over records. You are trying to help direct them to make sure that they have scoured their whole agency for everything they are supposed to turn over. And if they fail to turn over something that they were clearly ordered to do, that's ammunition for you later, right? That's a powerful argument you'll have later when you say, Judge, you ordered way back in October that we be given access to all reports, information, and documentation relating to this family going back to 2017. And now, 4, 5, 6 months into this case, we're finding out that there was this whole other box of records, or this whole other set of information we weren't given access to. So being clear up front about what you're looking for can help you down the line in that way too. A tip for you, I would encourage you, speaking of being specific in your requests or your motions, if you are interested in any way, interested in seeing for any reason email communications between social workers and other people about the case, specify that. In my experience, social services does not always consider social worker emails to be part of the quote file. And so if there is a investigative social worker who has emailed his or her social worker supervisor, you should consider asking for access or making a motion for access to copies of those emails as well. Obviously, attorney-client privilege is not going to be on the table, but social worker to social worker, or social worker to third-party physician or police officer or neighbor, that information you might be able to get access to. And it can benefit your client in your case. I had a really contested adjudication when I was with social services, a really contested abuse adjudication where it wasn't the straw that broke the camel's back in the case, but it really hurt the department's credibility with the court when partway through this hotly contested adjudication, my opposing party, Respondent Parents Council, produced emails that he had obtained through discovery requests that showed that two of the investigative social workers by email the night of an investigation following a pretty scary domestic violence incident for the family were making light of it. They were arguably being sarcastic and flippant about a pretty serious issue. And he was able, the parent attorney was able to use that information, that email, to say, this is what my client, when you are trying to punish my client for not working with social services. Judge, when DSS tells you that my respondent mother has failed to embrace the department as this helpful tool that it says it is, you should know that this is why, because she has a sense that this was the treatment she's getting from these workers. So anyway, just a tip to consider including emails in those requests. Child welfare records, of course, social services records, there's a complex web of confidentiality that surrounds them, more than we're going to get into this afternoon. That's good news for some of you, maybe not so good for others, but I do want to direct you to Chapter 14 of the Abuse, Neglect, Dependency Manual, which is free online through the School of Government's website. Chapter 14 of the A&D Manual, I think, I have nothing to do with that chapter. I'm not self-promoting here. I think it's a really useful tool. The way it is structured, it addresses records of different kinds and who can get them when. And so check that out if you're wanting some more information about confidentiality. But for purposes of our discussion today, understand that GS 108A80 acts as a broad prohibition on disclosure and redisclosure of child welfare records and DSS records. And then if you have an A&D case or a TPR case, 7B 700, which we'll talk about more in a moment, also governs the information sharing and discovery within those cases. And it also prohibits redisclosure of this confidential information. So I mention that to say, when you have these records in your hand, in your office, in your care, know that the confidentiality protections continue, even though they're out of DSS's hands and into yours. 108A80 means that you are prohibited from unlawful redisclosures yourself. And you want to be thoughtful about how you protect those records and handle them, and thoughtful about what you share with your client and how. And to the extent your client is going to get copies of records and leave your office with them, to advise your client to be smart about it, to not post records they shouldn't be on social media or sharing them in some way. So just keep that in mind. Okay, so a question that I get quite a bit: do parents have a right of access, an automatic right of access to their child, the juvenile's records, their child's DSS records? So I don't know if any of you have ever heard of this principle in media literacy. It's called Betteridge's Law of Headlines. And it's this notion that if a news article, for example, is titled with a question, the answer is usually no. Because if the author had good evidence to support a stronger headline, they would have used a stronger headline, right? The New York Times, if they have evidence that a high-profile politician has had an affair, is not going to title the headline, "Did this politician have an affair?" It's going to say the politician had one. Well, so you could probably read into then what is the answer to this question: do parents have rights of access to the juvenile's records? The short answer is no. There is no right of automatic access for a parent to the department's juvenile's records. The administrative code gives a parent, as a DSS client, access to their client records. So a mother who has some sort of DSS file created about her has access to those records about her, but not necessarily to the records about the child. And in the vast majority of these cases, a lot of the information that you are going to want is going to be related to the child. And so how do you get access? How, as a respondent attorney, can you get access to those files? It depends on the circumstances, right? That's every lawyer's favorite answer. It depends. It depends on the context, depends on the circumstances. For example, it matters whether DSS is the petitioner. Is this an A&D case or a TPR that DSS has filed, or is this a private TPR? If it is an A&D case, which means, of course, DSS is the petitioner, or if it is a TPR that has been filed by DSS, then we're going to be primarily concerned with 7B 700. This is the statute in the juvenile code. It applies to A&D and TPRs, and it supersedes the rules of civil procedure on discovery. And 7B 700 addresses a few important points for your access to these records. First is this idea of information sharing. Information sharing. This provision allows DSS, it gives DSS the discretion to share with parties in a pending action otherwise confidential child welfare information. And it is designed to encourage voluntary information sharing before we get into discovery and motions and court orders. It is meant to loosen the reins a little bit around DSS and allow them to give you information that is relevant to the case. There are some limits on it, for example, around reporter identity or disclosures that would put somebody in danger. But for the most part, DSS has the authority to share with you as respondent counsel in a pending case these records. You should start there. If you are respondent counsel in one of these proceedings and you want access to DSS records, you should start by requesting it. Why? Well, one, it just may be more efficient. They may agree to it. Some counties I hear from, the standard practice is that the respondent parent without problem gets access to these records. Other counties, I understand that is not the case. But the other reason that you need to start with information sharing is because of the provision that comes next, which is around discovery. This provision allows for discovery, but it does not explain the procedures, right? So 7B, the juvenile code, does not talk about interrogatories, for example. But we know from this case, the caption of which is at the bottom of your screen, the slide there, in re MM. It's a 2020 case. In re MM, the respondent father noticed the social worker for deposition pursuant to Rule 30 and a separate motion for discovery. The trial court interpreted 7B 700 to mean that because DSS has the discretion to share information voluntarily with other parties, then a party that wants that information must first request disclosure pursuant to information sharing before that party can then make a discovery request. And the Court of Appeals found that was not error by the trial court. So a motion for discovery cannot come before a request for information sharing. That request for information sharing could be, for example, in the form of an email from you as an attorney to the department's attorney. And I would suggest having that request in writing if possible. It can be good for record-keeping purposes. Your motion for discovery, if you end up filing one, needs to be specific about the information that you're seeking, but also it needs to include the reasonable efforts that you made to obtain the information through information sharing first. And that's part of why I suggest having it in writing if you can, so that you can show you followed the proper procedures that In Re MM, as In Re MM interpreted 7B 700. A few other provisions in 7B 700 that are worth mentioning, I think. One is that a protective order, any party served with a motion can request that the court deny the motion, restrict it in some way, so grant it, but restrict the request in some way, or can defer discovery. But I think this is an overlooked provision in 7B 700, which is that the party requesting a protective order shall submit for in-camera inspection the discovery, meaning the documents, the information, the materials, and if the court grants that protection, that those records need to be preserved for appellate review in case there is an appeal. And so I would encourage you to make sure that those two steps are happening if DSS objects or files a motion to have your request for discovery kicked out. Make sure that that court is engaging in that in-camera inspection and preserving those records for appeal. Remember that there can always be local rules. I forgot I put this picture in here. This picture cracked me up. I took this picture just in May when I was in Los Angeles. visiting my sister, and I walked to a park, and this was the sign that greeted me at the entrance to the park. And I thought, I don't really know what I'm allowed to do in here because there's so many rules. So that came to mind when thinking about local rules. Remember that local rules can dictate procedures around discovery. The chief district court judge in your jurisdiction may have adopted discovery procedures. Now, those discovery procedures cannot contradict the juvenile code, but they can exist in addition to them. So you always want to be familiar with your local rules, and a reminder that you can propose local rules or ask that a local rules meeting be held too, by speaking with your chief district court judge or somebody in their office. But always be familiar with your local rules and know what it entitles you to or not in terms of records. And just again, a reminder about redisclosure, to be careful. Once you have these records, 7B 700 prohibits unauthorized redisclosure as well. So those are cases, that's your access, sort of a bird's eye view of your access in cases where DSS is the petitioner. What about if you are representing a party in a private TPR? So, private TPR, DSS is not a party. It could be mom versus dad. It could be some third party versus a respondent parent. But let's just say it's mom versus dad. DSS is not a party. That does not mean DSS's records are not relevant. Right? You may still need to access those records. The department may still have had a history with your client and their family. And so what are the procedures? Well, there's no information sharing request that you can go make of DSS in this case, because DSS is not allowed to disclose confidential information without a court order or a statute on point. And 7B 700 only applies to active proceedings where DSS is a party. So you don't have to request and shouldn't bother trying to request those records from DSS in this situation. And similarly, a subpoena is going to be insufficient. A subpoena does not authorize DSS to disclose these records. You want to jump right into a motion for an order. And so there are a few statutes that govern the disclosure in this case, depending on what you're looking for. Now, understand that if you're in, for example, a private TPR or some other civil proceeding, the process is different in a civil proceeding than in a criminal one. So, for example, notice. If you file a motion for an order giving you access to DSS records in a private TPR, the Department of Social Services, or not just a private TPR, but also a Chapter 50 custody case or some other civil proceeding, the Department of Social Services is entitled to notice of that request, and they are entitled to an opportunity to be heard. This is different than in the criminal world. If you represent a criminal defendant, the procedure is different in terms of notice to DSS and whether they get to be heard or not. What about an in-camera review? Is the court required to conduct an in-camera review of DSS records in a private TPR before orders disclosure? Remember the media literacy rule of thumb I told you. If it's a question, the answer is probably no. An in-camera inspection is not required, but the court might decide to do so. And you may, as the movement here, if you're feeling like the judge is resistant to letting you have these records for some reason, you may propose that the court conduct an in-camera review inspection. That's better than you getting just denied outright. So if the DSS shows up and objects and says, we don't want respondent to have these records or petitioner to have these records, for whatever the reason, and the court seems inclined to agree, maybe ask the court to exercise its discretion to conduct an in-camera inspection to determine if these records are relevant or material, or if there's any danger in your client having them. And you might also want to consider narrowing the scope of your request in that situation. Try to direct the judge's attention towards the critical information when you can, because sometimes I think courts understandably are overwhelmed. Their dockets are huge, and they are looking at DSS's banker's box of records and thinking, I don't have time to review 10,000 pages to figure out what this respondent gets. If they seem inclined to deny your request for records for that reason, maybe pointing them to say, Your Honor, we're really looking for records related to the February 2nd report and the investigation that took place following that report. Narrowing that scope might increase the chances that you get a favorable ruling. Let's see, I do see that I have a question asking, do you mean that it's not required as in the court does not have to do it sua sponte, or not required as in even if you move for it? Okay, good question. So what I mean is that the court is not required to conduct an in-camera review in a private TPR or other civil proceeding, whether or not a party requests it. The court has the discretion and can conduct an in-camera review if it chooses to. And there are times where, as parent counsel, it might be worth asking the court to do that. All right, let's talk about admissibility. So we're going to focus for the next few minutes on hearings where the rules of evidence apply. So I mean A&D adjudications, I mean TPR adjudications. But before I jump into that content, let me just remind folks that when you are not at adjudication, that does not mean that it's just no holds barred. Courts should be entering rulings and basing their orders on really weak evidence, right? There is still a standard. The rules of evidence don't apply at disposition or review hearings or permanency planning hearings. That's true. The rules of evidence do not apply there, which means, for example, hearsay is admissible. But the juvenile code tells us that the evidence at those hearings still must be relevant. It still must be reliable. It still must be necessary to the question before the court. So anytime you, as respondents counsel, are sitting in your chair listening to the department or the guardian ad litems or some other party's evidence and thinking, boy, this is pretty weak. Like, somebody is up there on the stand testifying that they heard their neighbor say that somebody at the grocery store said, my client did something bad. How can a court ever feel confident that a story like that, a narrative like that, is reliable? How can they test the reliability of that? They can't. So you still have the ability to object and say, Judge, Your Honor, remember, evidence at this non-adjudicatory stage still must be relevant and reliable. It still has to help you decide a material issue or a material fact was more or less likely to have happened. So you can still use the rules of evidence to guide the court, even if they don't strictly apply, and ask the court to use its discretion accordingly. So let's talk about everybody's favorite. It might actually just be my favorite topic, but it's Friday, so who doesn't want to talk about hearsay? Hearsay, as you know, is a statement made outside of court, offered to prove the truth of the matter asserted. A statement made outside of court, offered to prove the truth of the matter asserted. Written statements count. So we're talking this afternoon about records and DSS records. Written statements can constitute hearsay if they are offered, if they were made or written outside of court and are now being offered for the truth of what they show. And so that applies to DSS records. That applies to the third-party records that might be contained inside DSS's files. It applies to any documents that DSS or the GAL are offering to admit into evidence. And those rules apply to records that you are trying to admit. And so keep that in mind. The general rule is hearsay is inadmissible unless the person who made the statement is there to testify and can lay a foundation for the statement, or some sort of exception applies that tells us we can trust this statement is reliable. Because again, Your Honor, I was in the backyard. I heard my neighbor say that somebody at the grocery store, she doesn't know who, said that my client did this. That's not reliable, right? We have no way of testing whether that's reliable. But when a witness is in front of the court and says, I saw Jeff hit Johnny, now we have something that we can test the reliability of. We can test their motive. We can test their memory. We can push the evidence around and see whether it is good quality evidence or not. So reliability is key to admissibility. Let's say we are at a TPR adjudication. So TPR adjudication, we've had an underlying A&D. Now, maybe we're 2 years into this family's life in terms of court proceedings at this point, and a social worker takes a stand, and she testifies, respondent father's drug treatment counselor, told me that he could tell respondent father relapsed. We have an out-of-court statement, right? And it's that somebody could tell dad's relapsed in terms of his drug use. That out-of-court statement was made by the drug counselor, the treatment counselor, and it is being offered by DSS here. For what purpose? Well, presumably DSS is putting this testimony on to imply so that the court will know that dad has relapsed. Dad is using drugs again. That is the truth of the matter asserted, that dad has used drugs again. He has relapsed. The court counselor could tell. If DSS is offering this out-of-court statement for the reason for showing that what is said is true, then we have hearsay. That hearsay is only admissible if we can test the reliability of it somehow and be satisfied it's reliable. So either the court counselor needs to come in and testify, right? The court counselor, who is the one who declared that the drug treatment counselor, forgive me. The drug treatment counselor needs to come and testify because the treatment counselor is the one who is saying, I could tell dad relapsed. Well, how could you tell? What were the signs? Did you see track marks? Did he admit something to you? How do you know, right? You can push back on that evidence, on that testimony, if the counselor comes and testifies. Or some sort of hearsay exception has to apply where the General Assembly has told us we think the context the statement was made in means that it is reliable enough to come in. One more example, just to sort of set the stage before we talk about the business records hearsay exception and how it applies to this. Let's say we have a private TPR, and so let's say mom is petitioning against respondent father to TPR, respondent father. And mom testifies and says, right before Johnny's father hit him, Johnny, the juvenile, said, quote, I broke the glass. So mom is saying that she could hear dad and son in the other room, and she heard son say, I broke the glass. I'm the one who broke the glass. And then Johnny's dad hit him. If that statement, if petitioner is offering that statement for the truth of the matter asserted, it's that Johnny broke the glass, right? We probably don't care who broke the glass. This isn't a trial about a broken glass. This statement is probably being offered for some other reason, like to show the father's state of mind, that when dad pushed Johnny, it was not an accident. Maybe dad's trying to say, I didn't mean to hit him. I turned around and my hand cuffed his face by accident, something like that. And mom is trying to say, no, your fist hit his face the moment he said he's the one who broke the glass. So that is not for the truth of the matter asserted, which means it's not hearsay. So it would not be prohibited. So you always need to start. We have a habit of jumping to hearsay exceptions, but we always need to start, I think, by grounding ourselves in what is hearsay first. Is this out-of-court statement being offered to show the truth of the matter asserted? And the analysis will flow from there about whether it's admissible or not. So let's look at how this works with records. Let's say adjudication, DSS offers their own records on the family into evidence. Those records contain lots of out-of-court statements, right? So we need to know if they are reliable. How can we know if records are reliable enough to be admitted? The rules tell us, the rules of evidence tell us when we can rely on out-of-court written statements that are contained in business records in Rule 8036. That's the rule, the business records exception as it's commonly called. There are several elements to this exception, but I have great news. You don't need to memorize them because they are contained right in the rule. The first question is whether this is a business that has made this record and whether it is a record. And I will tell you the definition of both of those terms is broad, has been broadly interpreted. Basically, anything is a business, an organization, a government agency, a for-profit, a nonprofit, any of those entities are a business. And a record can look like a lot of things. It can be a memorandum or a report or a graph or any other kind of collected data or information. The record needs to have been prepared in the ordinary course of business, meaning this is the usual way that this business documents this information, and it needs to be done at or near the time of the event. And the information needs to be recorded by somebody who has knowledge of what they're saying, or the information needs to come from somebody who does. The record also needs to be prepared by somebody with a duty to the business to report accurately. That's a fancy way of saying an employee usually. So an employee of the business recorded this information in the way the business normally does. And then that information needs to be sworn to either by a custodian of the records or some other qualified person, either by testimony or by affidavit with notice to the parties. I don't want you to try to memorize these. The reason I put these up is in one part to highlight for you, this is about reliability. This is how we determine whether records, unlike oral testimony from a witness where you get to cross-examine the human being, what the legislature is doing here is saying, if these elements are met, we believe the records are sufficiently reliable that they are at least allowed to be admitted because they were prepared by an employee who has an obligation to tell the truth. They were prepared near in time to the event in question. And so that's what all of these elements are meant to speak to. If DSS is offering records you oppose, you should see if you can attack one of these elements. Maybe a social worker waited way too long, for example. Maybe there's somehow, because maybe you put in an information sharing request or a motion for discovery, you were able to discover that this report by the social worker was written 5 months after the events in question. I don't think it's a secret that many social services agencies are feeling understaffed these days. Many of their social workers will tell you that they have unreasonably high caseloads. Folks are behind on documentation, and that may be a valid. That may be no fault of the social workers. But at the end of the day, your job is to protect your client. And if you can poke a hole in the work done by DSS, whatever the cause may be, and say these records are not reliable, your memory 6 months later, 120 cases later, it can't be sharp enough that we can rely on what happened that night at this level of detail. So there are several things that I want to point out to you here about pitfalls, things to watch out for that I see commonly come up in questions I get from judges or from parent attorneys or from DSS attorneys from my job here at the School of Government. One goes back to that issue about whether evidence is being offered for the truth of the matter asserted. So let's say DSS, maybe you've seen a version of this before. DSS stands up and says, Your Honor, please admit into evidence these documents that detail every Child Protective Services report that this agency has received on Johnny's family going back 11 years, since 2015. And you might think to yourself, boy, the petition is really about this incident from last February. And now they're offering up records about every report that this agency has received on the family going back 11 years. Well, the way that social services has been allowed to admit those reports that maybe have nothing to do directly with the allegations in the petition is twofold. One, don't shoot the messenger, but sometimes parent attorneys failed to object to it, and so courts let it in. So be on alert for that. The second reason is because of this argument that Judge, we as DSS are not offering these reports, this history, for the truth of the matter asserted. We're not trying to say that in 2015, Dad dropped the baby on purpose. We just want you to know, Judge, that we have a history of reports, so we're familiar with this family because it explains the steps that we took in this case. We're not trying to show the misconduct alleged is true. We're trying to explain to you why we took the steps we took in this case. Because if evidence is offered, if an out-of-court statement, which those prior reports are, if those prior reports are offered not to show the truth of what they say, but for some other purpose, like explaining the conduct of a social worker, then it's not hearsay and it's admissible. So you want to be on alert for when DSS tries to offer several years worth of family history reports. is it relevant? And what is the purpose? You want to stand up and say, Judge, what is the purpose with which DSS is offering this information? Because if it's for substantive truth, then it's hearsay and it's generally inadmissible. You can also argue to the court that to the extent social services says, we're only offering these prior reports for the purposes of explaining our conduct, the steps we took, you can then say to the court, okay, but we don't need 11 years worth. The amount of detail that the court gets, if we're just trying to understand why DSS filed a petition in this case or went out to the home or called law enforcement first, the amount of detail the court needs is probably fairly limited. And the court needs to balance that against the potential prejudice to your client of getting 11 years worth of CPS history that does not speak to the reasons we're in court now. So back to our hypo, we have a DSS attorney who says, Judge, we're at adjudication. Here are our records. They were prepared by an employee close in time to the events. According to protocol, all parties were given 2-week notice. Is this satisfactory under Rule 8036? Well, we don't have bright line rules for what some of these things mean, but I want to highlight them for you to consider for arguments. One is that because of a rule change several years back, these records can now come in through an affidavit and not just through a witness. So you've probably seen this. It is very typical now for these records to come in through an affidavit of the records custodian. The court does not have to accept the affidavit. The rule 8036 allows a court to accept business records through an affidavit, but it does not have to. And so there may be times where you as the parent attorney might stand up, for example, in a case where the records are speaking to a really critical issue, right? For example, was this injury intentional? Was this intentionally inflicted or was it an accident? Or maybe it's a really complex issue that the case is about. You may stand up to the court and say, we need a live witness in here. This is way too important of a point, way too critical of a fact to just have an affiant have signed a piece of paper saying that this whole box of records is true to the best of their knowledge and was prepared in this way. We need a witness. And I'm thinking about cases I've seen where, for example, it's hospital records and there's 300 pages of emergency room records. And on one of the pages in the margin, somebody, and we don't know who, has handwritten in, this was non-accidental. That could be a really important piece of evidence in some of these cases. And it's reasonable for you to stand up and argue, we need somebody to come in and say who wrote that and what their basis is for that information. Because, Judge, that is too critical to just let slide based off an affidavit. Is this a nurse? Is this a doctor? Did somebody tell them this? Did they come to this conclusion or opinion on their own? We can't just have this come in through an affidavit. The other piece is about notice. There is no bright line rule about how much notice is sufficient. So you want to be thinking, how extensive are these records that I've been given by DSS? When did I get them? How long has DSS had them? Did they sit on them for 6 months and now I'm getting them 2 weeks before with this affidavit when you're thinking about your arguments about how to keep evidence out. And remember, go back to reliability. That is the key to the business records exception. And you want to be especially careful with this fear around double hearsay. Double hearsay. The fact that something qualifies, as the Court of Appeals has told us, the fact that something qualifies as a business record does not necessarily mean everything contained in the record is sufficiently reliable. Trustworthiness is the foundation of the business records exception. I am bringing this up because DSS's voluminous records contain lots of stuff, statements from lots of people, and then other parties' records. And part of your job is to encourage the court to screen out the junk, okay? So if the social worker's records say, Johnny's dad attended 3 visits, supervised by DSS, and all the elements of 8036 are met, that's probably admissible. The social worker is documenting her work and the family's involvement with her in the standard, typical protocol following way that DSS records this information and reports it. This is not hearsay within hearsay. But if the social worker's records also say, Johnny's teacher told me that his dad was drunk at the parent-teacher meeting. So now we have an out-of-court statement by Johnny's teacher that dad showed up drunk to the school. That is an out-of-court statement, and the party offering that information wants the court to know your client was drunk at his kid's school. That is hearsay, and it's hearsay within hearsay. So just because DSS was able to lay the foundation to have those records admitted into evidence under the business records exception doesn't mean that every statement contained in is sufficiently reliable to be considered as evidence in this case. You will want to stand up and say, we object to that statement being included in the records that are admitted into evidence. There's no foundation here. We have no way to test the reliability of whether dad was drunk at that parent-teacher meeting. The social worker has no personal knowledge of that. They need to get the teacher here if they want the teacher to testify to that. The reverse side of that coin, another double hearsay issue to be on the lookout for, is records within records. You've heard me mention a number of times today, DSS files often contain the records of third parties, right? So school records, police records, anything like that. There's a real question about whether social services can lay a foundation for third-party records, because how can the social worker testify to the process the school undertook, for example, in creating that business's records? How can the social worker lay the foundation for emergency room medical records or police records or psychiatry records? They probably cannot. It goes to reliability. We have to know the process these records were created in order to feel confident that they are sufficiently reliable for that hearsay to come in. And I put a citation at the bottom of the page there, in re SDJ. That's a really interesting case. I think it's worth reading if you're ever wrestling with these issues. That case, when you first read it, you're going to think that doesn't help me. That helps DSS, because what that case said was that a social worker was sufficiently competent to lay a foundation for a drug lab, a third-party drug lab's lab reports, their records. And the court said the social worker can do that as long as they are sufficiently knowledgeable about the process, about those elements in the business records hearsay exception. But if you read the case, the reason I think it actually helps parent defenders is because that case allowed a DSS employee to establish that foundation for the drug lab, where the social worker was highly familiar with the process of the lab, so much so that the social worker actually collected the urine sample, ordered the report, and filed the report and the results with her office. My sense is that that is not typical across the state for how most DSSs interact with most drug labs. Typically, your client is going to be going to, for example, LabCorp. The social worker will have nothing to do with the entire process of the lab, the test, the results, other than maybe setting up the appointment or driving your client. And so I think you can contrast your facts with those in SDJ if DSS tries to admit, for example, lab reports, school records, some other third-party records without a proper foundation having been laid. All right. Next topic change. Judicial notice. This is the last one for me, and then I'm going to tag in Anik to talk about the DHHS manual. Judicial notice at TPR, we're going to focus on this. Judicial notice has become a big topic over the last several years in the juvenile world. And to some of your frustration, I probably can't get into it quite as much as you'd like here today, but I want to highlight a few really important things for you when you are combating DSS, trying to have the court take judicial notice of vast records. You can probably tell from the picture I used here what some practitioners will tell you the state of the law is around judicial notice in these proceedings. Judicial notice traditionally in other proceedings and once upon a time in juvenile proceedings stemmed from Rule 201 of the Rules of Evidence. And it meant that a court could take notice, could acknowledge settled facts of the world. What are settled facts of the world? Meaning things that are really not able to be contested. Raleigh is the capital city of North Carolina. That is a settled fact. Judge, we ask you to take judicial notice of that. We ask you to take judicial notice of the fact that the Carolina Hurricanes won the Stanley Cup this year. Those are facts of the world that parties, for efficiency purposes, shouldn't really have to spend a lot of time and effort putting evidence on to show. If it's relevant for some reason in the case. But the meaning of judicial notice has changed drastically in the juvenile world. So what I'm about to talk about don't apply to your work in other courts. This is really unique to juvenile cases. And it really happened, momentum in this area, the change that this topic has undergone really happened during the 2-year period where the North Carolina Supreme Court was hearing direct appeals of TPRs. And so let's see how judicial notice changed. So let's say we're at a TPR hearing, and meaning there was an underlying abuse, neglect, dependency case. Hearings have been held, non-secure orders, adjudication, disposition, review, or permanency planning hearings have been entered. Witnesses have testified. Evidence has been admitted. The court has found facts. The court has drawn conclusions and entered orders. Parties have complied with those orders or they have not. There's a whole wealth of history in this case in the underlying A&D. And now we're at TPR adjudication. And your DSS attorney stands up and says, Your Honor, we ask that you take judicial notice of the whole thing, all of that stuff. What you should hear after that sentence is what you see on your screen, which is your mouth saying objection. Objection. There are a ton of issues here. The parent bar has been upset at what I sense is its feeling that a dam has broken open in this area. That at this point, there's a big body of case law that has broadened the meaning of judicial notice beyond it was 85 degrees on February 1st, to what a court, a party, an order, a piece of evidence, everything that has been done in these cases now, it feels like courts can take judicial notice of. If the parent bar wants that fixed, it may require at this point some sort of legislative change or an appellate decision reversing course. But for now, what can you do at the trial level? You can object and you can be ready to argue why the court should limit judicial notice in some way. And I want you to leave this webinar knowing when the best opportunities for you to object are and your most the points at which you're most likely to be successful. When the court takes judicial notice of prior adjudication orders, that means it is taking notice of findings of fact and conclusions of law. What the Supreme Court has told us is when the court does that, those findings, those conclusions they're binding. That includes stipulations or admissions that your client made at adjudication under A&D. So the court at TPR adjudication may take judicial notice of an underlying adjudication order, and your client is collaterally estopped from challenging that at TPR. So that fact, that conclusion that, dad hit Johnny, Johnny is abused, that is cemented at that point. But what has happened, and I think what is concerning to the parent bar, is that non-adjudicatory orders are also being taken, judicial notice is also being taken care of those. Why is that arguably an issue? It's because the rules of evidence don't apply at those non-adjudicatory proceedings. So we're at a TPR adjudication where hearsay is prohibited, where the rules of evidence apply, and now the court is being asked to rely on orders from hearings where those things weren't true. So if the court at a review hearing made a finding that the juvenile is behind academically, that the parents have not made progress, we do now know from some of these appellate opinions that a trial court can take judicial notice of those orders despite that discrepancy in the rules of evidence. However, if the court is asked to take judicial notice of that, you get to rebut it. You are not collaterally estopped the way you are from adjudicatory orders and findings and conclusions. So you get to rebut it. You can attack the prior evidence that supported those findings, like that the parents weren't making progress, or you can offer new evidence that to the contrary, that the parents did make progress. So remember that you are not handcuffed by non-adjudicatory orders when you're at TPR. You can challenge those findings. You can put on new evidence that are contrary to those. Courts are also asked to take judicial notice of prior evidence, not just prior orders, but a note that was admitted into evidence from, for example, a juvenile's therapist. Again, the court has the discretion to take judicial notice of that information according to our appellate law, case law. But the rules of evidence apply now. So what we also know from those opinions is that if the evidence does not pass the rule requirements as they apply at the current hearing, then the court cannot take judicial notice of it. They can take judicial notice of, for example, previously admitted business records that would qualify under the business records exception. But a handwritten note from a therapist that does not meet the exceptions requirements, the 8036 requirements, the TPR court cannot take judicial notice of. So when DSS stands up and says, take judicial notice of all the evidence in the file, all the DSS records that were previously admitted at permanency planning hearing when we wanted to change the plan to adoption, that does not mean the court can take judicial notice of all of that now. Part of what you want to do is to find places where you can weed out the worst crap. So court reports, we have some opinions that say courts at TPR can take judicial notice of prior court reports, but it's not great. They're tricky because there's so much incompetent evidence in there. And so I'll let you read those opinions, but what they really stand for in my mind is that trial courts need to still have competent evidence on which to base their opinions. And hearsay loaded throughout prior admitted court reports now at TPR ain't it. It's not going to be enough. And you want to force DSS to be specific. Don't let that DSS attorney just stand up and say, take judicial notice of everything throughout the history of this case. Get them to limit what they are asking the court to take judicial notice of and be specific in your objections. Say what evidence, how can I respond when I don't know what it is they're offering this court or asking this court to look at? They need to narrow their request so that I can be specific, judge, and so that you as the gatekeeper in this case can make an informed decision. It has gotten way too sloppy, the process of having courts just handed, or even not handed, but just told that they get to consider this wealth of information, and nobody is really sure what is coming before the judge or not. So try to force DSS to be specific in its requests so that you can be specific in your objections, and hopefully the court will be specific in its rulings. Final point before I hand this to Anik. DSS may want to wave a magic wand that terminates a parent's rights, right? Judicial notice has opened the door, but it is not a magic wand. Prior orders, previously admitted evidence alone cannot support a TPR. There has to be competent evidence in the record at TPR adjudication in addition to whatever the court takes judicial notice of. So don't get overwhelmed. It's easy to get overwhelmed, but try not to get steamrolled by a department that stands up and tries to sort of wave this magic wand. Records alone are not a sufficient basis for a termination of parental rights. No judicial notice of prior records. Otherwise, the court could terminate a parent's rights at permanency planning hearing. They can't. There has to be a TPR in order to terminate their parental rights, and they have to have competent evidence at that point. All right. I know that was a lot. With that said, you can email me anytime if you have questions. Go ahead and put questions in the chat now for the next 30 minutes if you want. I'll be able to monitor it while Anik is going, but I appreciate your attention. And Anik, the floor is yours.
Happy Friday, everybody. Today's shout out is to you guys for sitting here through this during a week that many of you are probably trying to be on vacation because it's Judges Conference. So I really thank you for your time. So what are we going to talk today? We are going to talk about the manual and how it can help you. Because here's something that's really interesting to me. You know how we always say that the social workers have like too much stuff to do? That also means that they probably don't have enough time to refer back to the manual. And one of the things is also like if they've been around for a really long period of time, then they have probably forgotten what is in the manual. And the manual changes constantly. How do I know that? I know that because in coming up with this presentation, I realized that they updated the manual again last month. So the manual is constantly evolving. So where can you find the DHHS manual? I have, by the way, you're going to get my slides, so you don't need to worry about like trying to figure out like how to write all these down. I have a link to the manual, but it's also on our website. So if you go to the links on the For Attorneys tab, you're going to find a link to the manual. And one of the things that I want to tell you that is new that I noticed that they changed last month is that there are now, the manual is divided up into applying to PATH counties and non-PATH counties. This is not something that you need to worry about. NC PATH is actually a new program that DSS is using for tracking children. All counties, my understanding is all counties will be NC PATH by the end of the year, but it's mostly about like record keeping and how kids are being tracked in the system. But the policy is the same regardless of which type of county you're in. So what I want to show you is what the manual looks like, right? Because this is a little bit not something we're used to seeing. As lawyers, we see one thing, and that's what we're supposed to be doing. So what it shows is on the left-hand side, you'll see a column that says protocol, and it says what you must do. So what I like about this is that now when I'm looking at that, I know exactly what the social worker is expected to do, and that's usually based on law and policy. And then there's a column to the right that says how you should do it. So again, if they're not using, in your case, the practice that is being given, the guidance that's being given, then you can use that to argue that maybe they're not using the best practices. So let's talk a little bit about what my presentation is going to be about. I'm going to talk mostly about documentation and timelines, and hopefully visitation, but I want you to know that 30 minutes is not long enough for me to cover everything else that's in the manual, right? There's stuff about investigations, there's stuff about shared parenting, there's stuff about family searches, substance use, and so much more. If you have a question, by the way, the manual has a very useful Control F feature. You can put in a word and you can search to see where it is in the document. So let's talk about documentation. When I was a DSS attorney, because Timothy is not the only one who was on the dark side for a period of time, I will tell you that I don't know that I knew how much documentation social workers actually have to do. I think when I really realized how much documentation social workers had to do was when we started hiring social workers for the IPR program, the Interdisciplinary Parent Representation Program. And a lot of the questions that the social workers were asking during the job interview was, one, how many forms do we have to fill out? And do we have to account for every minute of our day? So that's good to know. You need to know that there's a lot of documentation they have to do and that they have to keep track of every minute of their day. So let's talk about what that looks like. Some of the documents that we may want. Now, Timothy, I will never be able to look at a question and think, is the answer no to what my question is? But anyway, what documents do we want? At the beginning of the case, we're going to want a couple of things, right? Investigation notes. By the way, there's a DSS form for that. I have put the DSS number next to every document that I could, because then you can just Google the DSS number and they'll pop up. So we want the investigation notes. We want any substantiation notes. That's where they meet and they decide whether it is more likely than not that neglect or abuse or dependency occurred. You're going to want to look at records from the investigation. Timothy already talked about this. Maybe there was a school report or hospital documents, right? You're going to want to see those. You're going to want to know what collateral contacts the social worker made. Who have they talked to? Because you're going to be screening those for hearsay in the documents that you look at. You're also going to want the most important document, which is the narratives. The narratives are the social worker's notes about everything that they're doing in a case. So they are supposed to be writing these down and submitting them within 7 days of something occurring. And my understanding is that the way that the narratives look now, because remember, I'm old time, is that there's actually a date that it says when it was created. So you can see whether things have changed from what the original was. And by the way, I have heard that sometimes narratives change over time, or was it submitted later on? 6 months later, you might not remember that mom was really great at a visit, right? So you want to look at when the narratives were conducted. And then I'm going to talk about two of my favorite forms. We're going to talk about the Family Assessment of Strengths and Needs, DSS 5229, which, by the way, I don't believe I knew existed when I was a trial parent attorney or a DSS trial attorney. I learned it through one of you. One of you included this in your record at trial, and I was able to use it on appeal. So kudos to whoever that was. And the risk assessment, DSS 5230. We're going to go through those two forms in a minute. And of course, a family services agreement, which is often signed before we are involved. You want to look at what that is. And anything your client has signed. How often do we get in a case and realize that our client has given away the farm and we might want to take back some of that? So you'll want to make sure, and our clients, they have a lot going on. They might not have kept everything that they signed, and they probably don't understand everything that they signed. So you're going to want to take a look at some of those. So let's go back to looking at the risk assessment, right? One of the reasons children are removed, the only reason children are removed, is because there's a safety risk. So the safety risk assessment is really important to know. So there is a case decision tool that is in the manual for almost every kind of situation. Substance use, unhoused, domestic violence, just a whole bunch of different things. You'll want to look at the decision tree for the case that is involved in your personal case. So here's what they're looking at, though. Has the maltreatment occurred with frequency, or is it severe? Are there safety issues? Would the child be unsafe if they were left in their home? Notice, right, this is the note that always gets everybody mad, including the parents, right? Which is, I already put my child in a safety placement. So why are they filing a petition now? Well, the reason is because if the parent was to return to have the child with them, would there still be a safety issue? Has the safety issue been removed or not? Is the child at risk of future harm, and is the child in need of protection? So you have to answer yes to either one or more of these questions. And I think it's also really important to know these questions, because then that's how you evaluate whether there's still a safety risk. So let's look at the form. This is 5230, Family Risk Assessment. And what I like about this form, when you look at it, is that it shows you, yes, I'm at that stage where I have to keep putting my glasses on and off. So what it does is that it shows you a risk level. So if I have a neglect score that is like a -1 to a 2, in that low category, if you kind of look across on that top one, right, abuse or neglect is a low score, or maybe a moderate, but they're at the 3, I might argue that it's really a low, and therefore there's no need to remove the child from the home. If it's a 6 to 16 or 6 to 12, it's in the high, then I might not have a great argument to make. I have to try to figure out how can I lessen this risk level. But you should be aware that there are a couple of things that override. These will override it to high no matter what the point value is. So sex abuse is one of them. right, where the perpetrator is still in the home, non-accidental injury to an infant. By the way, I also see cases with non-accidental injury to an older child. That's not a high, right? A serious non-accidental injury that causes the child to go to the hospital or get medical treatment. I saw a bruise the other day used as an override. That's not sufficient, right? Or death, of course, of a sibling happening. So one of the things that is helpful, I think, as an attorney, is when we look at this form, DSS 5230, there are some things that we can control and our client can control, and some things that we can't, right? So some of the things are like whether there's been a prior report, what is the age of the primary caretaker. Believe it or not, if you're over 30, hey, they're giving us points for that. If you're a single adult in the home, that is an issue. So some of these things are controllable and some are not. So I think knowing what they're looking at, what they're checking is helpful to you in trying to see if you can lower the risk level. And that's because a risk assessment has to be redone later on. So let's talk about my second favorite form, which is this one. DSS 5229, which is strengths and need. And I only put a short little blurb on that, but I think the reason that this form is really important, and it's not just important in the form itself, which again will also have a score. I'm looking at the wrong form, but it gives points and it takes away points. Like if a parent demonstrates good coping skills, then it's a -3. So it will lower everything. If they have good parenting skills, it's a -3. So again, it will lower the risk. And I think this is easy to then identify and to use to argue for why the child should be placed back in the home or why your client should have more access to their child. And again, if we know what DSS considers to be a risk, then it's easier for us to identify and work with our client on what they need to do to improve. So things that they're looking at are emotional or mental health, parenting skills, substance use, housing, basic physical needs, family relationships, which a lot of our clients don't have, right? Do they have family that can help them? Child characteristics, like whether the child has medical issues or chronic problems, support systems, caregiver abuse history, communication and interpersonal skills, i.e. is your client angry when they interact with the social worker, right? These are all things we need to tell our clients that they're being judged on so that they know how it becomes important. By the way, both DSS 5229 and 5230 come with an instruction sheet that tells you a little bit more about definitions. And you can use these definitions to cross-examine the social workers. You can put up the social worker and say, hey, I see that my client had a low risk. Why is it that you felt the need to remove the child? And did you follow the definition that the form says that you should have used in assessing the risk? So that's why I think that these two forms are really good. And the other thing is that our clients are always told that they are not worthy. And I think we need to pump them up, right? Tell them how great they are. Look at the strengths you do have and how can we help you in the areas where you might have needs. So all these assessments are really important. And I apologize, this is probably a little blurry, but you're going to want to look for documentation from the assessment, the investigation team about whether the decision was substantiated or services needed. But you also might want to know whether or not there was an investigation that was not substantiated or services not needed. So sometimes they will say that a child is safe with a plan. That means that you still right, there's still some concerns about safety there. And then the other thing is that the agency is told that they have to pursue custody if the safety threats cannot be controlled by interventions. Now, there is a 6-month limit, which is why sometimes you're wondering, why are they filing this petition now? This kid's been out of the home for 6 months. There's no danger. Why are they filing a petition? Well, they're filing a petition because they're required to at this point. If a child has been in a safety placement for more than 6 months, that parent is entitled to an attorney to fight to get their kids back. So you want to look at those assessments. So what about documents to request? There is a handy timesheet. They have like a whole spreadsheet on like what documents should be done at what point. So I'm going to kind of quickly go through these. Due within 30 calendar days of placement, the family services agreement, which they have often signed before we were even involved or before they were even removed. Something to show that they made diligent efforts to identify and notify adult relatives. And again, the push is for children to be placed with relatives instead of stranger care. Documentation of those diligent efforts to locate. And Charisse in our office swears that LexisNexis is the best way to try to find all these relatives, and you want to know who they've tried to locate. But Connect reports are also really important. If you've not heard of Connect, they're going to be doing a CLE for us in the fall. This is sponsored by DHHS, but it tells you on how you can help find relatives both on behalf of your client or the DSS should be using these diligent efforts. Then you can see their DSS 5317. Let's see the relative notifications that they're sending you. And are they doing more than sending out a letter? Because I don't know about you, but I only check my mail like once every 3 weeks. So like, is there a notification that's sitting somewhere in somebody's box? Are they actually making a phone call? Are they sending out emails? What efforts are they doing? Then again, within 30 days, they have to do a review of that family assessment of strengths and needs. Has the situation changed during the first 30 days? Which is, by the way, if you don't have Timothy's first 7 days as a parent defender, you need to get it. And the reason is we want to push efforts right at the beginning so that when they do reassessments, it shows that our clients are gaining in strengths and lowering their needs. And then, of course, we're reviewing their risk assessments yet again. And the child's life book. The child's life book is apparently anything that the child wants included in there, but in my opinion, too often there are not enough photos of the child with their parent. So we're going to want to look at that and making sure that we have opportunities that during visitation, for example, we take photos with the child and that we make those available. These are supposed to document a child's life while they are in foster care. And so I think that we also need to make a good effort to not only see what's already in there, but maybe even add to them with things that are positive about our clients. Things like, for example, maybe a photo of like the visitation was at a park and, you know, mom's at the bottom of the slide waiting to catch the child. That's great parenting, right? We want to show that. Then what about documents that you should be reviewing within 60 days of a child being removed? Well, again, the narratives, we want to see how the story changes because here's the truth. We're all human, including the social workers, right? They're very human. And the thing is that while they may be getting along with the parent at the beginning of the case, at some point, they're going to get tired of this parent. Especially if they don't feel like the parent is making enough progress, if the parent is getting anxious or less cooperative, the longer the case drags out, the tone of the narratives is going to change. So I think we want to make sure that we remind our clients that they need to be cooperative or at least friendly with the social workers, and we want to gauge that through the narratives. We also, again, within the 60 days, if they haven't completed it already, the investigation is finished, so we want to look at that form. Again, strengths and needs assessment, risk assessment, family risk reassessments, and the family services agreement is going to be updated within 60 days. And then, very important document, family time and contact. Visitation, in other words, right? Which is that the visitation plan, by the way, that I see that is entered within the first 7 days of a child coming into care should not be the same visitation plan that I see at the 60-day mark. In other words, I want to see that increasing. And I'll tell you why in a little bit, in a couple slides. So these are documents that have to be completed by social workers within 90 days from the last one. So we were at 60 days plus 90 days, so we're at 150 days. And every 90 days after that. So 150, 180, 210. I can't keep doing math, but you can do it, right? So these are the ones we want to see. Permanency planning reviews. We're constantly tinkering with that. Is it working? Is it not working? One of the things that it says in there is transportation. And if the reason that mom isn't getting to drug tests or drug treatment is because she doesn't have transportation, we need to be addressing it. And I think sometimes our clients are, they have difficulty asking us for help, and they certainly have difficulty asking for help from the person that took their child from them. So sometimes we have to be the ones that say, do you have what you need? I see you're missing some visits or you're missing some things. How can we help you? And let's change that permanency plan. By the way, my slide is in front of me, which is why I'm pointing in the front. We also, have updated service agreement. I'm sorry, the permanency planning review was whether or not we're still on the right road to reunification or whether we need to consider different plans. That is very focused on the child, by the way, instead of on your client. But you want to see, how are things going? When I'm in court, sometimes I hear things like, Johnny's had a cavity ever since he came into care. Why has that not been addressed, right? So it would look really good on behalf of your parent client to say, hey, I'm concerned. My son keeps telling me that his tooth hurts every time we have visits. Why is this not being taken care of? Once again, we're looking at the family strengths and needs assessment, the family reunification assessment, right? So these are all important. What about contact? The reason that I put what about contact, again, now I can't think of no. That's the answer. It's a question. What about contact? So within 7 calendar days of placement, the social worker has to have a face-to-face with the children in addition to the one that was on the day of placement. A face-to-face with the placement in addition to that they had on the day of placement. And there has to be visitation, family time between the child and parent caretakers. And by the way, this is usually very frequently before we have the first non-secure or at the first non-secure. So there should have already been a visit. That's what our clients want to know is, when am I going to get to see my kid? Within 14 calendar days, we're talking about shared parenting meetings, family time, which is, again, visitation plan. And if the siblings are not together, then we need to have a visitation plan for that. At a minimum, the social workers have to have ongoing monthly contact both with our clients and with the children. So we want to make sure that we remind our clients, I hate it for you, but the social worker is going to be up your you-know-what, and they have to contact you. This is the minimum. So you're going to want to look at the safety risks. We're going to review the paperwork from the investigation, and we're constantly going to collect and review the social worker notes and the narratives. Okay. I'm not going to have a lot of time to talk about visitation, but I did want to talk about visitation, right? Because visitation appears 103 times in the Permanency Planning Services Policy Protocol and Guidance alone. So what does that say to you? It means that it's super important. It's also in the Juvenile Code, 7B 905.1 says that you have to have visits, right? So it's really important because it's got to address who can be there, how not only will a child be transported, but how will a parent be transported to the visits, whether they have to be supervised, monitored by whom, and whether there's other types of visitation that are permitted. This is what I want you to take away. This language that is on my next few slides, these are in the manual. These are on page 94 of the Permanency Planning Manual. Frequent and meaningful visitation should occur because they help maintain the relationship. They help to see the children, to see their parents, to understand what their parents are doing, for them to feel more comfortable. And it gives an opportunity for the social worker to see that the parent-child relationship is continuing and that there is a good indicator that reunification is going to be successful. It's important for parents because it makes them more likely to want to complete their family services agreement. What I see as a really big barrier is when the parent has been making progress and we're not increasing their visits. And by the way, I now have come to observe several of your courts, and I will tell you, I see, even though DSS doesn't want to move for more visits, I see excellent parent attorneys asking for their clients to have more visits. And part of it is that maybe DSS doesn't have to be the one to supervise, right? Let's look at other people that can supervise the visits. Children need visits. We need to increase the visits. It really makes me mad when I hear people say, well, the child cries when they separate from their parents, so we need to lessen the visits. Well, that's not true. The reason they cry is because they don't know when they're going to see their parent again, right? They don't have a calendar that they can say, oh, I'm open next Thursday at the same time, same place, right? So they need more visits because then they'll feel comfortable that they're going to see their parent again. And same thing with parents, right? Parents needed to remain attached, remain engaged with the process. So contact is really, the social workers are supposed to stay in contact with everyone. And I'm going to put in a plug for my incarcerated parents. The manual only says that if a parent is incarcerated, that the social worker has to go meet with them at the jail or facility and have them sign a family service plan. But what I will tell you is that I don't see them doing that. I see them mailing it. They'll go to the local jail, but they won't go to prison to meet. But the reason you need those parents involved is because that's a whole other branch, right? That's a whole other set of family members that could help provide care for this child so that they are not in stranger care. So I am out of time. Just make sure you're going to have my slides. I apologize. I cannot stay on. I am flying out in like less than 3 hours. But you have my email. Make sure that you email me if you have any questions. I'm happy to answer them. And I did see that, Barbara, you printed out the manual. I love it. Just print out the section that you need to question the social worker about it. I think that is a great idea, and thank you for putting that up there. Timothy, any closing parting words?
No, other than to say, Anik, thank you for doing this, especially considering your travel plans. Everyone, thanks for joining. If you have any feedback or questions in the evaluations, we welcome them all. I hope it was helpful. And I hope everyone has a safe and wonderful weekend. Thanks all.
Thank you. Bye-bye.